talk about wearable computing today, wearable devices, Internet of Things. And the reason why we're doing this, of course, is first of all because, with all those wearables, we have them all the time. They collect a lot of information. They can build very detailed profiles. There's a big change in terms of scale in the intensity of the collection. The other thing, of course, is that when you have a small wearable, you don't necessarily have a screen. So user empowerment can be quite difficult in that context. Third thing is that we see a lot of applications in the context of health and well-being apps. So we'll discuss when we're collecting well-being data, when this well-being data becomes health data, because this can be a bit tricky. So hopefully we will have the answer at the end of the panel. And the last thing that we'll probably discuss is the fact that those devices, basically, they bring up some new economic models. We've seen insurance companies that give wearable devices to people, and if you behave in a nice way, basically you have a kind of reward at the end of the month. And so this can change the paradigms and change the models. So today, basically, we're going to speak about life tracking, wearables, data flows, try to understand how it works, who is collecting the data, and what are the benefits and risks of all those wearables. And we have a very distinguished panel today to speak about this. So from left to right, Jules, who will be Polonetsky, who will be moderating the panel together with me. He's from the Future Privacy Forum, which is a Washington-based think tank, and they're working on all the hot topics like big data, location, wearable, and so on and so forth. And previously, he was also the chief privacy officer at AOL and DoubleClick. We have Tobias, who works for Microsoft. He's a senior legal counsel at Microsoft and works on privacy compliance in the company. And I think he has a PhD in law. We have Cecilia Alvarez, who is from Pfizer, pharmaceutical industry. She's a lawyer, and she is also, I think, the vice president of the Spanish Privacy Professionals Association. We have Sjoera Nas from the Dutch DPA, who's been working at the Dutch DPA. We've been working together for many years, and before that she has also been working with EDRI and Access for All. And finally we have Claudia, who is working for DG Connect at the e-health unit. She's been working also on all the e-health and m-health issues at the European Commission, especially the green papers and things like that. So we're going to start with Jules, who is going to present very briefly the work and recommendation at the Future of Privacy Forum. Then we'll have very short statements, 3 to 5 minutes is the guidance that was given to the speakers. So we have plenty of time for discussion within the panel and with the room. We want this to be very interactive, so please jump in, after they had their introductory statements. Thank you.
Thanks so much, and we apologize for the heat in this room. Hopefully we won't get it too much hotter with our debate and discussion. If whoever's at the back door can maybe even open it a little crack, if it's not too noisy, the cross draft might be worth a little bit of the noise, and we'll all speak a little louder. Do you think we can give us a crack? Yeah? That'll make a little difference for sure. So thanks for joining us. We have some very rock star competition in some of the other rooms. So you who are here are clearly the people who are deeply thinking about wearables and the hopefully both benefits and risks that are involved. We at the Future Privacy Forum focus on being the centrist voice in many ways in privacy. We're optimists of the great things that can be done with data, but quite aware and concerned about the risks, and are constantly looking for solutions that can be used by policymakers, by chief privacy officers, by others who want to shape a democratic and responsible path forward. A couple of key issues that I hope we'll see teased out during the theme, and which I'll use to set up a little bit the code that we have been working out with a whole collection of both global tech companies, small app developers, wearables providers, and we've been taking input following the GDPR's progress, following the DG Connect's progress, following various standards, best practices, and we're trying to coalesce some ideas that can be consistent amongst many of those. And among the challenging issues are, if we could maybe pop to the first slide here, and Gwendall already sort of put this on the table, is this a black and white question? Are we talking health, which means an operation, medical care, insurance, and all of those obligations? Are we talking nothing? It's simply wellness data and can be treated like all other data. I think everybody would agree not, but the question is there a spectrum that can be used to help inform the way policymakers draw lines if the law sweeps wide, as evidently it shall? Is there room, however, for different treatment, whether it's understanding what is compatible, understanding what is legitimate, or is that too liberal? Does that open up too much risk for the kinds of unacceptable practices? So Sjoera was telling me that perhaps we should be careful about looking at the language and seeing how exactly it is set up in the GDPR, right? So Article 412, we obviously have, or this changed, jump in, tell me if I'm wrong, we have data concerning health is related to the physical or mental health of an individual, including providing healthcare services which reveal information about his or her health status. So that's a nice broad statement. It doesn't give us real precision. We can debate how wide or how narrow that is. And then we had a recital which data pertaining to the health status of a data subject, which may reveal information about the past, current, or future physical or mental health status of the data subject. And a lot of guidance that seems to be very medical, although not necessarily. So the critics can read this and say, well, this covers anything because anything can be discerned from my weight is probably a very good piece of information. If you know my height and weight, that's probably 98% of what maybe an insurance company wants to know, or some basic information. Or we could read this and say, well, clearly there's some difference between how many steps I took, even though it could be of value. It's very different than my precise medical diagnosis. And maybe there's room for differences when we think about, is advertising ever appropriate? How wide can my specification of purpose be? Does it need to be a consent for every step, and so forth? So in the code that we have been drafting, if we can pop to the next step, just some high-level principles, and delighted to share it with anybody who wants to go into greater depth, and we'll hear a little bit more about the other codes. Opt-in consent before sharing the data, if somebody wants to share it. A ban, you may not, even with your express consent, share this with data brokers or third-party ad networks. We all recognize that there will be concern that even if it's with opt-in consent, if the buying and selling of this sort of information becomes part of the commerce world, we have a real danger of losing trust, even with an express consent. The big question, I think, will be, is there ever a role for advertising? And we'll talk about some of the different approaches. This language here takes an approach that no behavioral ads, no ad networks like we know. However, I use an app called Runkeeper for my only occasional jogging, unfortunately. And every so often it says, congratulations, you have reached your personal best. And then it has some promotion for me. Or what if I have the Why Things scale, which I have, and it is constantly telling me that there are other products that this very fine French company has that maybe I would also like to download, or some partners that work very well where I can connect such. That's advertisement, perhaps, right? Or there could be an advertisement tied to more precise data. The DG Connect code, as you'll see, focuses a bit more on, is it a context ad? So we'll go into the detail later. And then what about research? There is a huge appetite, as I think everyone knows, from the researchers of the world who believe that perhaps they will discover great insights that are not available. They only have research from very specific audiences. Can they make it very easy for you to share data? We have a huge effort in the US, and there are similar efforts in the EU for precision medicine, so it may be necessary for many people to voluntarily share. What sort of consent? Is this a human subject research consent where usually you sit down and you go through a deep process? Or is there a way that I can agree to some wide use of my data for many purposes? How can that fit well into, and so here we point to ethical review boards. We'll learn more as to whether the EDPS has useful opinions on this, whether the DPAs have opinions. Where does ethics fit into legitimate interest? We have academic review boards, long tradition of scientists and researchers going for ethical review. Can companies who are doing, well, it's health research, sort of, they want to have insights, but it's also commercial. Is there a notion of an ethical review, and how does that fit into data protection law? All right, I won't go into more pieces of the code, other than to just put on the table that as we talk, I hope you'll be listening for how wide and how narrow can a specified purpose be? What is the role of advertising? What is the nature of consent for these devices? And Gwendall is giving me the hook, so I'll close with that.
Well, I'll pass the floor to Sjoera, because the opt-outs for tailored third-party advertisements makes me think that you believe that it's never medical data, and I think the Dutch DPA has been doing an enforcement action on Nike, and maybe they can elaborate a little bit on this to clarify, you know, the border between medical and health being data.
So we investigated last year the Nike Plus running app, which is a very popular free app to help you run. We published the results 2 months ago. It's downloaded 10 to 15 million times on the Android platform, and it's app number 12 in the Netherlands on the iOS platform. And the app is connected to a Nike Plus account, which is required on Android and very useful and highly recommended on iOS. And once you create that account, data are transferred to the servers of Nike, and they are stored there for an indefinite period of time. All the data collected through the app. Now, the app we investigated uses height, weight, gender, location, accelerometer, so the speedometer in the phone, to calculate distances, velocity, burned calories, stride length, and fuel points. This is a Nike-specific metric to calculate the level of exertion. And with the help of those metrics, Nike collects per user over time the frequency, duration, and intensity of runs. So these are the facts we established. And now we had to conclude whether these were health data or just regular personal data. And so we found that Nike is actually is able to conclude based on these data, if you go to the next one, whether a condition is improving or deteriorating. Do you do the same 10 miles faster or slower than last week, and how about that compared to last year, and how about compared to that 2 years ago? And we discovered in medical literature that there is a very strong accepted relation between how often and how intensively you exercise, you run or walk, and your life expectancy. So we quote a number of medical sources in our report underlining this strong relationship. So, last but not least, because we are always listing all the circumstances of a specific case, it's very difficult for us to say in general when is something health data, but in this specific case, a last element, if you can...
I have already switched to the next one.
One more, please. It doesn't work. Wonderful. Well, anyway, we also found that Nike calculates average achievements per segment, and a segment is called a community, and it's men or women in the same age group, or people performing in the same performance category, like amount of kilometers run. And they offer in the app at least one comparison with your achievement of the number of miles or kilometers you've run and the achievements of people in the same age and gender group. So this is a comparison that allows Nike once again to draw a conclusion whether you are performing better or worse than people in your same age and gender group. Then we concluded...
Are we too fast here?
Yes, one back, please.
Sorry.
So then we concluded based on this whole set of circumstances, Nike is indeed processing data concerning health. That is prohibited under Article 8 of the current Data Protection Directive, unless there's an exception. Well, Nike, as a private company, cannot use any of the specific medical exceptions for people bound to medical secrecy. So the only logical exception is explicit consent. But then we found, if you go to the last one, that the information in the Nike app was not enough to actually be able to obtain explicit consent. They didn't specify that they did mention in their privacy policy that they were collecting some sort of sporting data, but they didn't specify well enough what was happening with it and what they were exactly doing. For example, research and analysis and the creation of segments in which average achievements were compared with other people. We thought all of that is really necessary to inform people beforehand, before they can decide to hand over the data to you for that purpose. Now, I want to say one more thing, that Nike actually is not in the advertising business, in the behavioral advertising business. Nike is actually a company selling products and not profiles. So it was quite nice to work with this company because, you know, in the end, we had a mutual interest in making sure that data protection law is complied with. There was no essential conflict in the business purpose of the company with compliance with data protection law. And Nike, during the inspection, already announced a number of measures and is now further executing measures that we are inspecting, and in a number of months we will give the final word whether they're compliant or not. So we did a summary of all the conclusions in English this time. It's available on our website. It's 6 pages. Thank you.
Can I jump in and I guess ask, clearly laying out the appropriate detail so when the user downloads the app, they're informed and they say, yes, I would like these things. But I understand, I think, from the decision, settlement, there also will be an obligation for each different use to have a separate permission. And so I guess what I was sort of debating in my mind when I read it, I said, well, if I'm downloading a fitness app, not a pedometer, fitness to me means I get on my treadmill at the gym, it tells me right there that it's my calories burned. There's a whole collection of things that are usually close to fitness. Is the guidance that my Wi-Fi scale and the other apps who are reading this and hopefully understanding, what do they need to take from this, that they need an express separate permission, opt out or opt in, for calories, for energy, for each element of processing here? Or can I have one opt-in? We will provide feedback to you that includes your steps, your calories, all these very useful things, including how you do compared to everybody else. I got an email this morning as if the people at the Y-Things, the French Smart Scale and other things maybe somehow knew we were all meeting. Turns out everyone got it because I posted right away what I got on Facebook. I said, here's what I got today. And it said to me, Jules, happy 2016. In 2015, your average number of steps was this. Here's how you compare not so well to the average user. Here's how many times you got on the scale. Here's how often most people weighed themselves. And I looked at that and I said, well, wait a second. Hopefully they informed me. I don't remember. But let's assume they informed me. Would they have had to give me 10, 15 permissions? Or can we group these things in some way, given that it's less than medical, but clearly sensitive health?
Can I just give a very simple answer? This is one consent question. Everything I described in this investigation can be solved with one proper consent question, as long as the information is detailed enough that people understand what they consent to. This is one company offering one running app. There's a lot of alternatives. So as long as people are informed, this is what we intend to do, and as long as it's sort of proportionate and sort of expected, logical, within the logical expectancy of use, there's no problem at all asking consent for 10 different purposes in one consent question. It would be different if there was only one running app worldwide, no competition, or it would also be different if the purpose would be totally unexpected. For example, and this is not the case in Nike, I'm not slandering any company here, this is just hypothetical. For example, if a fitness company would have as a separate purpose to sell it to insurance companies, that could not be consented away in the same consent question because it would be totally unexpected and too invasive.
Yeah, so maybe we can jump to Claudia, the European Commission, because maybe the mHealth Code of Conduct is going to give all this guidance and tell everyone how to develop the apps and collect consent and inform the people. So what's in this code, basically?
Yeah. Thank you. We are developing, or let's better say, the European Commission is facilitating the development of this Code of Conduct on mobile health apps. The Code of Conduct itself is written by industry organizations. We have an industry drafting team in place who are writing this Code of Conduct. And the Code of Conduct will cover all apps that are processing health data. So that is the target group. And of course, in this Code of Conduct, we're also coming to the difficulty how to define health data, as this is obviously not such an easy thing to do. The Code of Conduct is also, it's targeted at app developers, so it should make it easier for app developers to comply with European data protection legislation, as these app developers are very often small or medium-sized companies without legal expertise, and it's not very easy often to understand the data protection requirements. And the Code of Conduct is therefore written in really accessible, simple to understand language. It's at the moment around 10 pages. We have published the first draft last year in December at an open stakeholder meeting. The Code of Conduct, or let's say the draft, because it's not finalized yet, is currently published on our website. So there you can all see the current draft. We have had it open for consultation until mid-January, and we're now at the moment in the process of updating it. What is in this Code of Conduct? Exactly some data protection principles that app developers should follow, such as how to obtain consent, some transparency, information on transparency, what information do I need to give the user when he downloads this app, principles such as purpose limitation, you can only collect the data for specific purposes, data minimization, we have included the principles of privacy by design and privacy by default. For instance, if the app can, for instance, share data on a social network, this option should by default be switched off. So there is a lot of provisions in there. The user's rights, also indeed provisions on advertising, as we have heard, provisions on secondary use of data, security obligations. We have also at the end, we have two annexes, one for privacy impact assessment, a draft template, and one draft template for a privacy notice. So with this Code of Conduct, we really want to increase the user's trust in mHealth apps, because at the moment it's clear that users do not trust these kind of solutions because they're afraid of what will happen to their data. Will it be sold to insurance companies? Will their employer have access to it? So this should really increase users' trust, and that's basically it.
And will it be enforceable, basically? Because sometimes that's a question people have with codes of conduct. They say it's a nice piece of paper. The industry says, yes, I comply with the content in the code of conduct. And in fact, if they don't respect the code of conduct itself, they're not necessarily kicked out. So how is this going to be addressed in the governance of the code?
Yeah, thank you for that question. That's really an important question. And indeed, this is one of the few questions which still has to be solved within a drafting team. Actually, we're going to have a conference call tomorrow, because we have now, so at the draft in December, we did not yet have a governance section because the drafting team could not agree upon how the governance should be handled. Now we have a draft governance section, but which will only be discussed tomorrow. And under the new General Data Protection Regulation, codes of conduct will become even more important and will have a stronger weight. And there is also a new article on the enforcement of codes of conduct. So enforcement will become really an important thing. There needs to be a body in place to enforce the code. So we will, of course, take this into account. There needs to be some kind of governance body. If apps say they are complying with the code, but they're not, there has to be, of course, some sanctions. That's clear. That's a necessary prerequisite to obtain trust and to make this code really work. Because
Claudia,
otherwise it's more a guideline.
How do you deal with what gets captured and what doesn't get captured? So when we were working on the wearables, we realized you don't wear all wearables. You may sleep on them, or they might live on your bedroom wall. There's many devices in this smart home system that are capturing information about me. Maybe my voice control, my Echo, or other devices can detect that the tremor in my voice means that I'm hoarse. There's many things that are physically capturing physiological data. Where do we draw the line between this is something that now can be used to infer something medical? The big data experts tell me that what I shop, which we didn't always consider sensitive medical information, but my diet is, again, probably more interesting even than my exercise. I'm told that I can exercise less if I stop eating, and that it's almost all about eating. So stop eating and things will work out a little bit better. So where do we figure out what is captured if I count my calories or something, I scan and I wear it? What's the line between data that's interesting and could be analyzed or explicit or sensitive? Is it a black and white line? Where do we draw the line?
Yeah, there is indeed no clear black and white line, unfortunately. As Sjoera also mentioned before a bit, it has to be really assessed on a case-by-case basis. We have received some indication of the Article 29 Working Party last year. They have written a letter to DG Connect on health data in apps, so where they have tried to explain when is personal data considered as personal data concerning health and when is it not. And there were some examples of, for instance, raw data, for instance, my steps tracked during a single walk. They would not be considered as health data because no conclusions could be drawn about my health status. But if these raw data are tracked over time and combined with other data about my gender, my age, my height, then conclusions can be drawn about my health. So it's really about what are the consequences. Whenever the data allows to infer my health status, then it should be considered health data. But indeed, as you say, in the environment of big data, it's often not very clear how to draw the line. But it really needs to be taken into account the level of sensitivity and what are the consequences for the user, because indeed health data is sensitive data. If somebody gets to know about my health status because of the tracking of my exercise, how it develops over time, how my weight develops over time, then a person can get to know a lot about my health.
And there's also a provision for an opt-out for even advertising that is not tied to the use of the app, but it's a fitness app, so maybe you're interested in sports, so sports ad will appear, or maybe a promotion for the other app that is the partner app for this app. There's a requirement to offer an opt-out. So in terms of human dignity, if we're saying like that's the case, that's the case. But are we then telling those developers, sorry, just please go on welfare or be charitable or something? What do we do about the fact that the other option is paying, which is a good option perhaps? I think they should get paid for their work. Maybe that's a good model, but are we officially suggesting that there's a requirement to provide an app with no commercial, even having my brand name very big is maybe advertising? So how did you get consensus amongst businesses to agree to no advertising?
Well, I mean, of course, the data subjects' rights always have to be taken into account. I, as a user, have to know what happens to my data. I mean, in the offline environment, it's very clear. I mean, if I go into a shop and I buy a piece of bread or whatever, and the vendor would ask me about what photos I carry in my wallet or the phone number of my aunt, I would not give this information. But in the online environment, this is less clear, and we give access. If we download apps, we give access to all our private data and the data of our contacts. How we have handled this, the issue of advertisement in the code of conduct, it's indeed we have distinguished two different scenarios. One was the opt-in and one the opt-out requirement. So we've said if there is the use of advertisement within the app, and if the advertisement is clearly linked to the functionality of the app, and if no personal data are processed, then opt-out would be sufficient. For example, I'm a diabetic patient and I use a diabetes app, and then I get like all the people who have downloaded this app get a specific kind of advertisement for diabetes patients. Then opt-out would be okay. But if the advertisement uses my personal data, if my personal data is sent to some kind of ad network and I get really personalized advertisement, then opt-out is not enough. Then I really need the consent, the opt-in consent for the advertisement.
Tobias, do you agree with this? Is this also what you're promoting in your company in terms of legal practice when you're talking to people who are developing applications, services, and so on and so forth?
Yeah, hello. First of all, glad to be here. I agree actually that advertisement is one of the crucial points when designing wearables, the model that Claudia presented us in the code of conduct that the Commission is currently working on seems very reasonable in a way, and then following what is otherwise common. What I'd like to do here a little bit is to say kind of how we, Microsoft, see the field, the development, and how then to react to that. First of all, a personal story. I'm not only at Microsoft, I'm also at the University of Helsinki occasionally, and I was on a sabbatical, and then I paid a visit to Lothar Determann in San Francisco, I think 3 years back or so, and he had this Fitbit, and he was like totally enthusiastic about it. And I was like, it counts your steps, that's interesting. And now I'm actually kind of supporting the Microsoft Band, which basically is similar. It's not yet launched in Europe, but the UK. But the market has exploded from step counters, and I think we see three different types of devices. So first of all, you see the quite simple ones that count your steps, and they might look nice or so, but they basically it's what they do, and then they process it. On the other hand, you see those that are smartwatches, and I think just recently we see a trend to luxury entering that. Did a little bit of research. Breitling launched the B55 at a price point from 6,000 to 8,000 euros for their constant horological smartphones, also quite expensive. So you see a different right, and they look like those, like those watches we wear with the suit, but they're actually smart devices. Most smartwatches look like this. This is a Polar one, and where you may or may not be able to download new applications, which leads me kind of to the second point on the field we're in. There's an ecosystem. It's quite similar. I've been on those panels like 5-6 years ago on talking about the mobile ecosystem. We see the same thing developing here, and as a minimum setup, if you wish, you have three parts. You have the device, i.e. this. It might be more or less ugly than this one. You have then applications running on the device, and they might be from the same producer or from a different producer. It might be that there's something running, let's take the iWatch, there are pre-installed apps, and then you can also install others, which is similar with the Microsoft Band. But then you have also the backend in most cases. Of course, you have solutions where they're poorly on the watch, but usually have a backend. Even with this one that I think is 3 years old, you can download the data, and then it's in a cloud storage, which has, of course, advantages in computing. But if you look at the legal level, then the opinion, or actually the side letter, which the Article 29 wrote, that probably if it's in the cloud, then the household exception wouldn't apply anymore. No. So those are the three main components of that. Now, what does it all mean, and what does the kind of what we heard all mean? Both the Future of Privacy Forum, which I was fortunate to be a part of on the wearables, and then the Code of Conduct from the Commission. Why do we have that now? And I think we have it because no one really knows what to do. That's, I think, and everyone is learning. And Microsoft is also trying to learn and find out what's happening, where is that going. There is a big demand from consumers. So I just mentioned a few names. I also did a little Wikipedia research, and I think there were more than 50 producers of those devices. It's like, Nike, like others, a lot. Everyone wants this, but everyone also sees there are privacy challenges. At the beginning, there were maybe more privacy challenges. Fitbit had a thing where people logged data as, and that was shared publicly as, let me quote from my head, vigilous sexual activity, 30 minutes, and that then there was a Techmodo article on that, and that's probably not something you want to be sharing unless, well, maybe some people want to share that, especially with the timestamp, but others usually want that. So there are those things. I think those kind of things, I think they are addressed by all the big manufacturers, so that you don't share without the consent. Now, I know we only have 5 minutes, so we're very brief. I think that the Code of Conducts industry-wide are the right way to go, and it's also within the company there should be similar privacy principles adopted. We started with very high-level principles, transparency, tell people what you do, user choice, and that goes not only for sharing whatever activity you're doing, and then security, and that's something I would really stress, because it's all fine if you do the privacy, but at the back end, if everything is taken and then someone else sells it for profiling, that's something that needs to be avoided. And I stop here.
But for instance, Microsoft, is also providing some operating systems in phones, and as you said before, there's different parts in this system where you have the device, you have the telephone, for instance, and you have the backend. So are you pushing for some specific practices to inform the users on the telephone itself, the way to present the information, collect consent, and so on and so forth? Do you have specific guidance that you give to developers, both in the sphere of the Internet of Things and also in other contexts?
Yeah. Gwendall, thank you for that question. There is definitely a specific guidance given to the developers, because they are actually the ones making it happen. They are they're crucial to that. And that the problem here is concerning the consents and so on, is that some of the devices, and maybe not the one I have on my right hand, and maybe not the Apple iWatch, but the Fitbits and so, they're quite tiny. So for a detailed consent, one that's maybe not the right place. If they have the app on the back end, you have much better possibilities. And so the consent is one part of the guidance, and it's in line with Works Microsoft. There's an account, and that through that account you can also manage it, and it's quite easy to do also the opt-out and opt-in, which will be maybe more difficult if you don't have like a whole ecosystem to provide. But that's definitely something you need to provide, because also choices might change. Giving people choices doesn't just mean giving them choices at taking it into use or not taking it into use, but also then later you need to provide those choices. All in all, I've made like 10 principles which were given to the head of the business and to the developers, and then below that, like it's a checklist, and below that then there is detailed guidance in the so-called Microsoft Privacy Standard, which are then used for the privacy impact assessment. So I'm actually very interested about this annex that Claudia mentioned to kind of check the impact assessments.
I'll note just one thing, that it's useful, when the app developing market first launched, you didn't see very strict rules from the platforms. You didn't have a lot of options on your phone. You had location. Now you have many options. When it's come to this wearables market, Android and Apple and Microsoft, as platforms that many of these app developers are writing for, put out reasonably, compared to where we were, forward restrictions. The ban that I mentioned on data brokers or third-party ad networks is part of the terms of the Apple and the Google Fit and other platforms, so that they're already saying to developers, that's not the model that we are willing to support. You risk being, kicked off our platform. So we're starting a little bit from a better place. When we were negotiating code, it was a lot easier to say, well, I don't know if you like that, but that's already the rule that you're living by. So let's, make sure we're at least putting it in the code, and then obviously looking at how it fits into the law. So we still have big concerns, obviously, to solve, but we're starting from a little bit higher playing field than, look, it's an app, it's not my problem, it's a program. Now, I just suggest for those of you who are thinking big and globally, if 20 years ago Microsoft had told me what programs I can download on my laptop, we would have had very big problems. In fact, Microsoft had very big problems with such issues. Here today, we're applauding to some degree the platforms when it comes to apps, which are the computing systems of the future. We've all given up, and even Android, which has a little bit more of a view of, listen, this is just an operating system. So I sometimes want to think big picture and say, great, please enforce these rules, don't allow anyone to do bad things, take complete control of the mobile operating system. But we're also then handing over a real, if I want to watch pornography, which is my right, yes, I think. Apple says, no, sorry, not if it's in an app. Go to the web, but in an app, we don't like that. And we already see, we obviously want to enforce these by law, and we want the platforms to do their job to be responsible, but I also always like to think a little globally about exactly who should be in charge of mandating as opposed to the regulator and so forth.
Can I ask a question?
Yeah, we can. If it's not too long now, but Cecilia hasn't spoken yet. So.
Question, because, by the way, Simon from TomTom, we do this wearables stuff, but as a European technology company, I've been looking carefully at GDPR and the code of conduct. I'm also looking at what Jules is doing. Now, I see light between the two. So what do? We take the European standard. What am I confronted with competitors who take Jules standard and do that in Jules standard, as I call it now, and have that in Europe, potentially?
Well,
that's a trade issue. So how do we level this playing field?
Well, I'll answer. We're certainly not trying to do a US standard. We're sitting with the GDPR and we're engaging this conversation, right? We can't tell people follow something that will be illegal in Europe. Most of these companies are trying to build globally compliant platforms. And so at the end of the day, you need to build for the most restrictive situation. So it's a good conversation, however, to have and to say, okay, well, let's really push and understand and figure out what is feasible, what is practical, and hopefully
so
come up with.
It's health data. I'm curious. There's a verdict now.
The verdict.
I think nobody
In any
debates.
case, the companies will have that operate in France or in Europe or in the Netherlands. They will have to respect the law in those countries. They already need to, and it's going to be more harmonized with the regulation in the future. And I mean, there will be more incentives, I will say, in the regulation to comply. So we can have this conversation later on, but I would like to pass the floor to Cecilia first, because we've seen that wearables are also being used in the research. They can be very useful in the research, and you can have some kind of, it can be difficult to find the right balance between the general interest and the purpose limitation and collecting consent by the user. So how do you use wearables at Pfizer today and tomorrow?
Hello, thank you very much for inviting me here first, and I will then address the question. I will not necessarily, or the experience that I will share with you does not necessarily depict what we are doing in Pfizer today or what we are going to do tomorrow, but of course they are part of the experience of Pfizer that will be embedded in what I am going to share with you. But I have also been in private practice for 19 years, and part of the experience also is coming from there, and of course from the study of the competitors, what they are doing in this sphere. I can divide it into two main purposes: the way in which the apps or the wearables could be used in taking into account the research context. One of them is in order to improve the efficacy of the medicine, of the drug. It will be the equivalent of the clinical trial in a deregulated world, let's say. This poses many regulatory constraints because we cannot, as researchers, we cannot do any kind of research without any kind of condition, without not controlling the accuracy of the data, and this means sometimes that we must be the one measuring. And when I say we, it is not the Pfizer company or the Sanofi one or any other of these kind of pharmaceutical companies. They are the hospitals, the investigators, the doctors who are doing this. When we are intervening is because we are sponsoring this. And the kind of information that we get from clinical trials are coded. Therefore, even if we get information that could be deemed health-related data that could be even useful for the purpose of a clinical trial on another study, we cannot combine this information with the one that we are obtaining from the clinical trials, because despite the fact that the DPAs are still saying that coded data are personal data, for us we are unable to identify these patients. And therefore we are unable to identify that a certain information that we may obtain from a wearable could be linked directly to a specific individual. What we can do is, of course, a functional separation, in the sense that we may infer a certain number of correlations that then will be the starting point for a real study afterwards with respect to other kind of rules. So this is limited from the very start, from the very beginning, for the constraints that we have in how we make clinical trials or studies in order to have a medicine that at the end of the day could be launched and used by human beings. So I will now turn into the second category, which is other kind of wearables or apps that are trying to improve the engagement of the patient or to help the doctor in providing the good therapy, or in order to help the doctor in having more information for a more tailored diagnosis of the patient. And this is something very different. The purpose first, and therefore the kind of wearable that we are having. Therefore, the main interest of Pfizer or any other equivalent company is not necessarily a life tracking, as it has been defined at the very beginning, but a user tracking. The life tracking is useful for the doctor who will then be looking at the results that the app will provide in a nice way and in a more accurate manner than just relying on the memories of the patient on when he or she has taken the last doses of whatever could be the medicine, or the last place in which the person has put an injection. So the app may help you in order even to have less suffering, in order to remember the place in your body in which the last injection took place, in order not to repeat in the same place, but to choose another one. It may help you in order to follow a therapy in which many caregivers are involved, in particular with children or with persons who have some problems of memories with respect to the time in which they need to take a pill, and not to repeat and take it twice, or to forget definitely to go to an appointment with the doctor, and to forget to go to the doctor with the right information in order that the doctor may have the good diagnosis. So all of these kind of things could be done through the apps in order to help you to make appointments, in order not to forget the time in which you need to take the dosage, in order even for the doctors to make the perfect dosage of a medicine. In order to have a better tailored medicine, sometimes it is not that you take for each patient the same dosage, and therefore your age, your height, even the feelings that you have the last time you took the medicine could be important in order to change the dosage, and this is a decision that the doctor will take. And the app will permit to have this kind, or at least will facilitate to have this information, and the patient will not forget this at home, because it brings the device with him or with her. One of the main decisions that we must take is as to whether we will only have the data in the device and therefore we do not access the data, or whether we are going to have the data transmitted to our servers. The decision is first driven by the purpose of the app, and many times we do not really need, and we are not interested in having this kind of information with respect to the life or the health information. Sometimes it is costly to have the data in our servers, but it is true that we can provide more security. One thing that causes me certain concerns is the fact that the users are not well educated with respect to their security, and they are basing all the security sometimes on the native security settings of the device, which are very poor because they have been designed for the consumers and not even for professionals. And therefore, what it is better that the historical data that have been taken by the app is sent by the email of the device, or it is better that is sent through the systems that I can secure in Pfizer, for example. For this, I will need first to authenticate the patient. I will need also to authenticate the doctor, and this is not that easy. Maybe I can do the authentication with the patient, which is the user, the first user of the device, but I need to have another mechanism for the doctor also to be engaged with this in order to be the only one available to open the data and to decrypt the thing, and this is not easy at all. So that these are part of the questions that we have. So part of the problems are not only that the app developers are not taking privacy seriously, is that the operating system manufacturers, the app stores, and the guidelines that they develop, and the device manufacturers, they are not developing sometimes the privacy settings that we need. And it is extremely costly to do this, and therefore sometimes you prefer not to have the data in your servers just because the reliability is too high, or otherwise you will be breaching the app guidelines. And I will pose you an example that this is not something specific for health. This is with respect to any kind of app. I am sure that you are familiar with the concept of the cookies in the websites. When you turn into the app context, there are cookies or similar technology that functions the same way, even if you do not consider them cookies technically. In order to provide an opt-out free and easy procedure for the user and say, no, I do not want to be tracked anymore, this is extremely difficult because the guidelines of the app stores do not permit you to use anything else than what they have designed, and what they have designed do not contain this. And this is something that is not related to this, but definitely to try to put the label of data controller to anyone, which is one of the tries of the Article 29 Working Party with respect to the app developers, the app stores, I don't think this is the solution. There should be rules for the technology designers, which are not necessarily data controllers, which do not feel themselves as data controllers, but which are part of the ecosystem that permits that at the end of the day we have better privacy settings for the users, and therefore also for the real data controllers that want to implement something that is more secure with respect to the users, and therefore that will engage the trust that we as Europeans consider that is part of the goal of privacy.
Thank you.
Before we go to questions, we want to maybe see if Sjoera can tell us about what we may learn tomorrow, the employer relationships with these fitness apps?
Maybe just before that, I had just a question for Cecilia, a very short one. So from what I understand from all the different speakers, we have different types of uses of wearables, basically. You have the leisure uses, like in the Nike case, where the benefit for the user basically is either self-motivation or comparing yourself to a norm, so we're all becoming normal paths in a way, or boasting, because you publish the fact that you ran 10 kilometers on the Sunday morning and your friend only did 9, so he's very bad and you're very good, basically. And then you have more other types of devices that are part of the medical relationship. So for me, it's quite different. This is more sensitive, I would say. So is there some kind of certification? You talked about the requirements in the systems, the fact that we need to be very careful about who can access the data and so on and so forth, but you also need to make sure that the device itself is accurate, is not measuring something which is wrong information sent to your doctor, which in turn give you the wrong pills. So is there certifications for those devices, or
It is not a certification per se, but most, I would not say all of them, but most of these kind of apps could be qualified as medical devices. The fact that it's a medical device entails another piece of regulation that has nothing to do with privacy, but definitely that interferes, let's say, in the way in which you are able to say that the kind of data that you are providing are accurate for a specific purpose. It is not accurate in an objective manner. It could be accurate for a very specific purpose that needs to be disclosed, and actually there is a lot of control in this kind of thing, not for a privacy reason beforehand, but the first step is to decide whether or not this is a medical device, and this has a lot of consequences in the way this is designed, and the every kind of pieces of information that is disclosed will be reviewed by doctors in order to be sure that the claims that you are saying, or the kind of how you can rely on this information, and also the limitations with respect to this information, is something that should be reviewed very carefully. And this is something that is done by nature, let's say, with respect to any medical device that is now is in another environment than the traditional one. But we have this, it is not a certification, but it could be a sort of path in which you have another regulation that provides you additional restrictions that helps for the accuracy of how you are going to use the output of the app.
Okay, thank you. So, Sjoera, what are we going to see tomorrow? What are the new uses and paradigms? One example in France is the question that Jules was raising. We saw some partnerships between an insurance company, AXA, and WeThings, that Jules mentioned before. And basically what they do is they give you a pedometer, and you wear your pedometer all day long, and if at the end of the day, during the month, you've been walking 7,000 steps per day or 10,000 steps per day, then you get a reward. But so they give you a coupon, basically. Is this also linked to new applications that we see in the workplace, or how are we using IoT devices today in various environments, and how is it going to change the paradigms?
We just finished an investigation of 2 Dutch companies that handed out wristbands to their employees, and we investigated, and we concluded that, again, because data were collected over time from the wristbands, from the employees, these were health data, and employees are not free to consent to the processing of their health data. They're generally not very free to consent to anything their employer asks them. That's why, because of the imbalance of power, we generally disencourage any employer to rely on consent. There should be a legitimate interest. But in the case of health data, it's really impossible to give explicit consent to your employer to process health data about you through the wristbands. When we alerted the companies to these provisional findings, they immediately stopped processing the data from the employees. What we did suggest is, like, of course, as an employer, you may hand out wristbands to your employees in the same way you would give a gym subscription. But the essential condition here is that there is no feedback at all, not even anonymized feedback from the wristband technology provider to the employer, because we think that the individual data would still be identifiable to the individual employees. Now, I have to say these were relatively small companies in the Netherlands, so we didn't have to define when the company would be big enough, like Microsoft type of size, where the individual employee would no longer be recognizable from the statistical data. But as a general advice, we suggest that you cannot get any feedback from the, be it an app or a wearable provider, that you hand out to your employees.
I think there was a question at the back, lady at the back.
Yes, my name is and I am from the Norwegian Consumer Council, and we have recently done an analysis of fitness apps and calorie counter apps, and one of the things we find is that data seems to be stored indefinitely as a default. And
This is one of the violations we concluded in our report. We are still in the round of inspections to see if all violations are terminated, so I can't really say what the output is till in a couple of months we'll publish the end results of our inspection. But for now it is a clear violation to store these data indefinitely, and also it contributes to the conclusion that those are health data because it's stored over such a long period of time. So maybe I'll ask Claudia too.
I absolutely agree with what Sjoera says. Yeah, it's simply illegal to store the data for an unlimited amount of time. If the data is not necessary anymore for the purposes for which it was collected or processed, it has to be deleted. So there has to be adequate time limits for retention periods, or if an app hasn't been used for, I don't know, let's say 2 years, then it should be also deleted by default. Or of course, if the app is deleted, the data should be deleted as well. And yeah, this is also something that we have reflected in our code of conduct.
I'll just quickly add, we have, so to allay my friend at TomTom's concerns that some companies will have some other, we have a similar restriction that data can only be kept for as long as needed for the specific purposes. I will tell you that is always the hardest piece. We do lots of negotiating codes and best practices, and when we talk to app developers and so forth, it's always the hardest piece because they say, well, I have plans. I'm now a 2-person company, but I'm going to be Microsoft, and today this is what I'm doing, but I'm going to be the platform for your entire life, and I will learn this and I will learn that, and so what will happen if I make a narrow? So he said, well, this is why it's self-regulation. You'll come back and say, I need more time.
So, but tomorrow portability will solve this probably. Cecilia wanted to speak, then I have one question here, a gentleman over there and the lady here.
I would like to make 2 comments with respect to the things that have been discussed. One is the freedom of the consent. I can imagine that I do not have the same power than my bank. I cannot imagine that all the banking agreements that I have been signing are null and void because I didn't have the real freedom to negotiate this with the bank. The general terms and conditions that we accept in the internet actually were created in order to have no negotiation, in order to have another kind of commerce developed. It is impossible that we negotiate things if we want to have e-commerce. So I think we should avoid saying always that there is no freedom when there is an unbalance of situation with respect to the parties that are in an agreement. In the labor environment, of course, the scope of the freedom could be limited, but depending on the kind of things that you are asking for. And actually, there are a certain number of things that should go with the way in which you are working, because it is necessary for this to work. I'm not saying that privacy does not have any space. What I am saying is that to say merely that when there is an imbalance of power between 2 parties in an agreement makes the consent invalid, I think this is too simplistic, and this is not in accordance with civil and commercial law. This is one statement that I would like to make as a user, not only as a user and as a lawyer. I have been a lawyer for many things, and not only in privacy, and privacy is extremely important, is not the only right. And that's why it is so important that we do not convert everything according to this kind of simplistic rules. The second thing is with respect to retention, and I finish.
Okay, because we just need to take the questions also.
The purposes of calculating calories, I think, will be different than when we are talking about scientific research. And I make this point, of course, because I belong to which I belong. But when we are thinking of scientific research, we should think about keeping the data as much as we can. And actually, the regulation of the biobanks, for example, will never have any kind of sense if you restrict this for 3 years, or for 5 years, or for 20 years, or for a specific purpose in the sense within the broad purpose of scientific research, because otherwise you will not be able to think, and you will not be able to make the research. It's like if I have had in my scholarship a professor telling me, please read as less books as possible just in case you have a bad idea coming, instead of saying, read as much books as you can in order that you have a bright idea coming, I think things would be different.
Thank you. So, well, 20 seconds per question. We take the 3 questions, and everyone will answer the questions here very briefly too.
Sjoera Nas Dutch from Privacy Laws of Business. My question is regarding Nike in the Netherlands. You were describing your negotiation. I was at a conference, Internet of Things conference in Barcelona in October, and this Nike person came from Washington State headquarters talking about the heat map of following runners all around London, for example. Question is, I said, well, what about, surely you must know individual data. He said, no, we don't collect individual data. So my question is strategic. Were you having a nice discussion in the Netherlands with sort of European-oriented Nike people, whereas in headquarters they were sort of ignoring these principles?
Great. One question for Claudia. How do you increase end users' trust by making the code of conduct to app developers? I don't see the connection. And one question to Cecilia Alvarez. If you make yourselves independent on the app stores for these kind of medical apps, why don't you just bypass them? You don't need app stores and their regulations in order to make a medical app. So that is one.
That's more than 20 seconds.
How can we control the collection of data when multiple users use the same device to avoid the analysis mistakes?
Sorry.
We didn't hear it,
We
sorry.
didn't hear it, sorry.
How can we control the collection of data when multiple users use the same devices to avoid analysis mistakes?
Okay, so you can react to one of the three questions, but very, very
Cecilia.
briefly.
With respect to the app stores, of course you can live without the app stores, but it is true that when you want to have a certain coverage or to have the launch, the way in which, for the moment, at this stage, it works is that if you are not in Android, in the big platforms, it will be your commercial possibilities of having this launched properly will be diminished. I am not saying that there are not other ways to do this, but what I'm saying, I'm not only speaking about Pfizer, and this is something related to my disclaimer. If the app developers or the app stores are not involved in the privacy from a technical point of view, it is not only Pfizer that may have some finance to do something else. There are many small developers that have not privacy, that have not money to pay lawyers and so on. So I'm not only saying this because of Pfizer. I'm saying this because the ecosystem takes into account these kind of platforms, and second, because the developers are many people who have no technical knowledge, lawyers' knowledge, privacy knowledge.
Tobias.
Yeah, just briefly on the top, and I think that the last question, then we'll go to the other half. Yeah. So very briefly, I mean, obviously from a privacy point of view, mixing identities would be a good thing in this way. From someone who tracks their fitness, it's not a good thing. And I think the way to do it would be through accounts. Actually, you would have different accounts, and you could also manage the data through the accounts. So
10 seconds each.
Yeah. I think we should talk outside of this room, but one thing is we make our results public. If you think we did something wrong, we invite the entire audience and all the specialists to send us signals that we missed things, just to make sure we know that Nike is processing location data from everyone. That is the essence of our report, so that's not a new finding.
Okay, and on the code of conduct, how to ensure end users' trust. So all the apps that are complying with the code of conduct, they should be published in a public registry, and we possibly also develop a kind of trust mark. So all the apps that are complying to the code of conduct, they are complying with data protection principles and are not selling the data to, I don't know, third parties without the user's consent. So these apps, they are really complying with data protection law, and therefore it will also increase the user's trust if they see this app is included in this registry or has this trust mark. So that's how it would increase users' trust.
Thank you all.
Yeah.
Thank you.